Welcome to Employment-Related Laws for Managers and Supervisors. You are probably asking, why is this important to me? Or better yet, why is this important to our company? As members of the management team, it is essential for you to be aware of the laws and regulations that affect potential and current employees. With the rise of employment-related lawsuits, the need for a better understanding of employment laws has increased significantly in today's marketplace. As your strategic HR ally, it is my responsibility to keep you abreast of all current and changing regulations that will affect your employees. This training will give you an overview of the most important employee-related laws that you need to know about. Let's begin. In an overview, this training session, we will discuss the following topics and how they will apply to you and your employees. We will also have a discussion on the common ways that these topics of the law are broken and ways that we can correctly address them. Discrimination, harassment, safety and workplace injuries, FMLA or the Family Medical Leave Act, compensation and benefit related laws will be covered in detail. First, we will talk about discrimination. Discrimination is a hot topic in today's workplace and culture. So what exactly is discrimination? It is defined as the act which negatively affects an individual based on their race, color, religion, national origin, or sex. So what exactly does that mean? Under employment laws like Title VII, ADA, ADEA, PDA, and USERRA, individuals who fall under these acts are protected from discrimination. An example might be not hiring a candidate based on their age, since most of your other employees are significantly younger. Another form of discrimination you may encounter is not hiring a candidate because she is pregnant and her due date falls during your busiest time of the year. Other forms of discrimination may be based on little things like their religion or their sex. The best way to avoid discrimination issues: only consider an individual's skills and experience to make what is necessary to perform a specific task or job. Overall, the best way to prevent discrimination in the workplace is to be involved in the daily activities and conversations with employees and stop any signs of discrimination practices or speech. For any questions or concerns, please contact your HR department. Next, we'll look at harassment. Unfortunately, like discrimination, harassment is another hot topic in today's world. Under the law, harassment falls into two categories: either quid pro quo harassment or hostile work environment harassment. Quid pro quo harassment is defined as a tangible employment decision based on the employee's acceptance of unwelcome sexual advances or requests for sexual favors, or unwanted activities related to religious nature. An example of this is when a manager requires a direct report to participate in religious activities as a condition of their employment. A hostile work environment is defined as a result of a supervisor or colleague and even a customer with whom a victim interacts with on their job, and there is a presence of unwelcome conduct that is either intimidating, hostile, or offensive. One example of a hostile work environment includes supervisors openly yelling at an employee in front of colleagues for making a mistake or using crude language in the office. What can we do to prevent harassment in the workplace? First, read and learn the company's clear sexual harassment policy. This is a useful resource on the federal laws that are pertaining to harassment, as well as clearly stating the company's position on it. Like discrimination, the best way to prevent and stop harassment is to be involved within the workplace and consistently stop any signs of harassment amongst other employees. Additional training for all employees and managers about harassment and the different types of harassment will assist in the prevention of any kind of harassment in the workplace. Managers can also consult HR if they have questions or concerns about harassment issues in the workplace. The health and safety of our employees is a major priority to our company. As managers, it is your responsibility to make sure all employees are performing their jobs in a safe manner. According to federal laws, including the Occupational Safety and Health Association, or OSHA, employees are required to perform their jobs safely, either by wearing personal protective equipment, PPE, or following the policies and procedures set forth by OSHA to make sure that they are being safe on the job. An example of PPE is a safety vest or having access to first aid equipment in case of injury. Properly reporting accidents and injuries is also covered under the state and federal laws, not only for the protection of the employees, but also for the protection of the company. This also means training employees to be safe in their respected workspaces. When an injury occurs, it is important that employees and managers properly report the incident as soon as possible. This plays into workers' compensation claims. If an employee is injured on the work site, properly documented notes of the incident will be important to determine if the employee is eligible for compensation claims or not. An example of OSHA negligence is allowing an employee to not wear proper safety glasses while working with heavy machinery. For example, if that employee breaks a piece of debris and it makes contact with their eye, they may have a claim to receive compensation from our insurance plan, since we, as the employer, did not ensure the proper safety procedures and protective wear for that employee. The most efficient and effective way to protect the health and safety of our employees is continuous training of the safety procedures and policies under OSHA. This may mean quarterly or even weekly meetings that are required to ensure all employees understand the proper ways to protect themselves while in the workplace. If you need additional instructions on what laws and procedures to follow, please see your HR representative. Next, we will discuss the Family Medical Leave Act, better known as FMLA. This law protects employees who need to take extended time away from work for medical reasons. Eligible employees for FMLA have worked at least 12 months, and during those 12 months have worked 1,250 hours. This leave is unpaid, and it does protect the employees from losing their job. We do offer our employees supplemental insurance, so they do have a portion of their wages being paid to them. This is usually 20 to 40%, depending on the insurance policy they have signed up for. Now, the FMLA Act doesn't just include pregnancy. This includes any employee who needs to take care of a sick child, an elderly parent, or immediate family who has turned ill. It is important to understand that FMLA requires employees to stay in constant contact with their manager as far as the time needed to be gone. Typically, 12 months in a rolling calendar is the length of time that is allowed under the Act. Finally, we'll discuss compensation and benefits-related laws. Under the Fair Labor Standards Act, or FLSA, it sets standards for minimum wage, overtime pay, and enforces those standards on all employees. For instance, if a stage wage is higher than the federal wage, the employee is required to follow state regulations and follow that minimum wage. It also enforces overtime pay and all record keeping. The Equal Pay Act, or EPA, is geared to protect wage discrimination based on sex. This means the prohibition of wage differences between men and women who have the same amount of experience and qualifications while doing the same job. An example of this may be Sarah, who has been on the job for 5 years as a project manager, and John, who has also been working on the job as a project manager for 5 years. John, however, is making $10,000 more than Sarah. If Sarah were to ask John his salary and find that he is making significantly more than she is, she may have a claim under the Equal Pay Act for pay discrimination. And finally, the Employee Retirement Income Security Act, or ERISA, are laws that set minimum standards for retirement plans, health plans, and the protection of these benefits. These standards also cover life insurance and disability insurance and apprenticeship plans. Health benefits are probably the most frequent questions you may receive from your employees, as our government is frequently revising their own use of health insurance. These laws protect employees by providing documentation that describes their benefits and requires notification of any changes. I appreciate all of you taking the time to listen to this employment law training session that will affect our interactions with employees in the workplace. Hopefully this training session gave you useful insight and tools to further train your employees. Whether it is harassment or discrimination, questions about safety and the workplace, or you have an employee who needs help filling out their FMLA paperwork. You always have the opportunity to come speak with your HR representative in case you have questions or concerns. Our goal is to maintain our partnership with you for a better workplace and to build a connected company. Thank you.